Hi, everyone. It's the Catholic CEO, Henry Katarna. Welcome to this Catholic Business Wisdom series topic today on the Unanimous Shareholders Agreement. This document is usually associated with buying shares in a company or having some partners get together and form a corporation, an LLC, or a business corporation. The Unanimous Shareholders Agreement can go by some other names, but it's typically called a Unanimous Shareholders Agreement because it's a document that you would sign when you become a shareholder that agrees to various business practices and decisions inside of the corporation. I have a list of over 30 of these, and so I'm going to try to group them for you into, let us say, groups of 5, just so that we can keep it simple and keep it short. I really do want to list them all for you for your consideration because they're all important. They all should be decided upon ahead of time before you go to your lawyer and your attorney. Because if you go to your lawyer and your attorney without the answers to these, you're simply going to burn lawyers' fees and time, and you're going to waste a lot of money, honestly, and you'll waste time. It's better to do these decisions outside of the law firm office or the attorney's office. Better to do them at home or inside of your company where your shareholders can have a serious discussion and agree to the items that are inside of the Unanimous Shareholders Agreement. Let's do the first 5. The first 5 are: how many shares are issued, who owns what percentage, are all shares of the same class, are there different classes of shares, and if so, why? And who are the shareholders, companies, individual trusts, or whatever? The whole point of these is to define some of the basics. Who are the shareholders? What percentage do they own? What kind of shares? Do they have different voting rights and different attributes to them? And if so, you would itemize all of these things so that everybody can see. This is the point. Everybody can see visibly what the actual details are about the shares. Let's go further. Another 5. Who are the directors? How is voting to be done? By shares or by show of hands? What is the procedure in the event of a disagreement on any matter requiring a vote? And how will the majority shareholder recognize the input or advice of the minority shareholder whenever a vote occurs, which can always be won by the majority shareholder? And then finally, who are the board members? So the point here is that you're trying to define who's leading this company, who are the directors by name, and how will you vote? Is it to be done by shares, by show of hands? What's the procedure if there's a disagreement on any matter that requires a vote? Is there to be an oral vote, a written vote, ballots, a certain time period for people to make their decision before being called to a vote, and so on? Particularly important is that situation where there might be a majority shareholder who owns, let's say, for example, 65% of all the shares. That person can, no matter how they vote, unless it's by show of hands, normally by shares, that person will always dominate the discussion and they will always get the answer that they want. And so perhaps you might have a different kind of process to at least hear the input of minority shareholders. Further, let's go to another 5. Who are the officers? What constitutes quorum for a board meeting or an annual general meeting or a shareholders meeting? What's the procedure for appointing another director or other directors? What's the procedure for dropping a director? Who is considered management? The staff, that is. Is there compensation and how is it determined? Will there be one or more advisory committees? And if so, who and under what topic? So you can see what we have here is a situation where we're starting to talk about procedures for appointing directors and about compensation. The board will be governed by advisory committees, which are different than governing committees, or the governing board itself is different from its advisory committees. Let's go further. What exactly is being vended in by each shareholder? The idea there is that some shareholders will buy their shares, but some may vend in property or intellectual knowledge or something else, and so you want to define that. Will shareholder loans exist? What is the procedure and priority for paying them out? What are the restrictions or rules and procedures for transferring shares to another? Will you carry so-called key man, key person insurance to pay for replacements in the event of the demise of a key executive? Let's say the CEO dies in a tragic accident. How do you replace that person? Where do you get the funds to do that? And key man insurance can help to provide interim, you might say, funds to pay for a replacement or for the entire process. Will you carry insurance to buy out a shareholder who becomes incapacitated, dies, is divorced, becomes bankrupt, or is charged criminally, and so on? So these are categorized into topics where you're talking about the ability of people to carry out their work. And the whole point, as you can see, is to define what the rules are so that everybody is aware of them ahead of time and they agree to them. Because in the moment of crisis, that's where disagreements occur, and that's where the consequences of disagreements are even worse. And so this is why in a USA, a unanimous shareholders agreement, you will have this level of detail. Let's do another 5. If a shareholder is removed for one or more of the reasons above, what is your wish as to how the shares are to be disposed of? What is the procedure? In other words, let's say somebody is incapacitated and then they can no longer be a shareholder, or they die, or they want to sell their shares. What is the procedure? What is your procedure if a shareholder simply wants to sell their shares? Will you have a shotgun clause? This is where a situation where a shareholder wants to buy the other shares. Those other shares have rights to accept or deny. But if they deny, they can or must buy that shareholder's shares at the same price originally offered. See, so there's some rules, and this is commonly called a shotgun clause. You also have drag-along rights. If the majority shareholder wants to sell their shares to a third party, they must include the minority shareholder in the same deal. That's called drag-along rights or come-along rights. It's very important. And where is the company head office to be located? What state, what city, what province? A further 5 topics. How is confidentiality to be handled? What other concerns does anyone have? There might be other unique situations that you would want to identify and portray inside of your unanimous shareholders agreement. Here's an important one. In the event of a sale, what's the valuation procedure? In other words, how do you arrive at the value of the shares? Is it an opinion, a shouting contest? No, or a third party, or the directors or others. In other words, how do you define the value of the company using an objective, usually third-party process that is agreeable to everyone and decided in advance for the perception of fairness and deliberate action? How are decisions made about issuing dividends? Where is the corporation registered? The registered head office of the corporation, which state or province, and whether it's federal or state or local or provincial or municipal. And have you sought individual professional tax and legal advice? And finally, what is your procedure in the event of a common disaster? You've heard of the situation where an entire executive team or a board of 5 or 6 people is in a plane crash, and suddenly the whole governing structure or the senior management structure of the corporation, the business, is wiped out. What do you do in that case? You can have procedures like not all 5 people fly on the same flight, or there's various ways to handle it. You can surely see how this could be important for many corporations, including family businesses. So there you have it. Those are a quick review of, I count 32 different items that I've identified that could go into a unanimous shareholders agreement. And I've come up with these 32 from past experience. And so I would suggest these to you for your consideration. And maybe you should be thinking of other additional features and points that could go into a unanimous shareholders agreement. And by so doing, you would arrange properly for the affairs of your corporation. So thank you again for joining us. It's the Catholic CEO, Henry Katarna. We'll see you next time.